The subcommittee will come to order. Today's hearing examines the troubled prosecution of former United States Senator Ted Stevens of Alaska, which resulted in the Department of Justice requesting the judge to overturn the jury's guilty verdict and dismiss the charges against him. The Justice Department's Public Integrity Section, with the assistance of two assistant U.S. attorneys from Alaska, prosecuted Senator Stevens. The Public Integrity Section is supposed to be the department's elite unit for handling political corruption cases. In light of what the prosecutors did in this case, I have to question the section's competency and ethics. In July 2008, a few months before he was to run for re-election, Senator Stevens was indicted for making false statements on his annual Senate disclosure forms. The indictment charged that he had not paid for certain renovations made to a home he owned in Alaska and failed to disclose the value of the renovations as gifts. The renovations were made by Vico Corporation, an Alaska company owned by the Senator's longtime friend Bill Allen. In order to allow Senator Stevens the chance to clear his name before the upcoming November election, his attorney requested an October trial date. The government not only agreed to a speedy trial, but suggested an even earlier date in September. The result was that there would be only 55 days between indictment and the start of the trial. Since this was a criminal prosecution, the government was required to produce all exculpatory and impeachment-type evidence known as the Brady and Giglio material. Pre-trial, the government summarized what it represented to be all of the Brady and Giglio material, however, in its possession in two letters sent to counsel for Senator Stevens. As would be discovered later, the prosecutors had made misstatements and omitted significant evidence in each letter. This trial started in late September 2008. Senator Stevens' counsel repeatedly asked the judge to dismiss the case because the prosecutors had failed to produce the evidence in violation of their Brady and Giglio obligations. Numerous times, the judge found that the prosecutors had violated their discovery obligations. While the judge declined to dismiss the case, he repeatedly ordered the prosecutors to produce the various documents required by Brady and Giglio. He sanctioned the government by excluding certain evidence. In late October, the jury found Senator Stevens guilty on all 7 counts of the indictment. As subsequent events would reveal, the jury reached its verdict based upon a distorted version of the facts. Soon after the trial ended, an FBI agent involved in the case took the unusual step of filing a whistleblower complaint with DOJ, and the judge, alleging in specific detail that his co-FBI agent and at least one of the prosecutors engaged in serious misconduct and unethical behavior in the prosecution of Senator Stevens. Given these serious allegations, the judge ordered the government to produce materials relating to the agent's complaint. Consistent with its behavior during the trial, the government did not comply with the judge's order. The judge had finally had enough of the government's noncompliance and held 2 of the Public Integrity Section's prosecutors in civil contempt. At this point, the DOJ assigned a new team of attorneys from outside the Public Integrity Section to handle the remainder of the Stevens post-trial litigation. They soon discovered that the prosecutors had failed to produce Senator Stevens' counsel significant exculpatory and impeachment information in the form of interview notes relating to the key prosecution trial witness, Bill Allen. After producing the interview notes to the judge and to Senator Stevens' counsel, DOJ took the drastic step of asking the judge to set aside the guilty verdict and to dismiss the indictment of Senator Stevens based upon the prosecutor's prior failure to produce the interview notes. While the case was tossed out, it was too little too late. Senator Stevens had lost his bid for re-election, and the damage done by the prosecutors was irrevocable. The judge was so concerned about the government's admitted Brady violations, combined with what he described as prosecutorial misconduct, to a degree and extent that this court has not seen in 25 years on the bench, unquote, that he took the extraordinary step excuse me, of appointing a special counsel, Henry Scholke, to investigate and, if appropriate, prosecute criminal contempt proceedings against the Stevens prosecutors. In November of last year, Mr. Shoki completed his investigation and submitted to the judge a 500-page report. The judge released the report to the public on March 15, 2012, and the facts detailed in that report have generated today's hearing. Mr. Shoki did not recommend bringing criminal contempt charges against any of the prosecutors due to what he concluded was a deficiency in the judge's orders. One might say that the prosecutors got lucky. Significantly, Mr. Shoki found that the investigation and prosecution of U.S. Senator Ted Stevens were permeated by the systematic concealment of exculpatory evidence, which would have independently corroborated Senator Stevens' defense and his testimony and seriously damaged the testimony and credibility of the government's key witness. Mr. Shoki's report describes a series of improper actions taken by the prosecutors and the FBI agent that are sobering. His report takes us inside a major criminal prosecution where he found that the prosecutors won their case through willfully failing to disclose exculpatory and impeachment evidence, intentionally failing to correct false testimony, making misrepresentations to the judge, to defense counsel, and even to people within DOJ, shirking supervisory responsibility, grossly mismanaging the trial team, and acting on questionable ethical decisions. Further discrediting the prosecutors, he also found that they had a collective memory failure relating to certain key events. As would be expected regarding any report like this one, people have criticized Mr. Shoki's conclusions, tactics, and tones, but there can be no dispute about the hard facts, which lead to only one conclusion, that Senator Stevens was denied a fair trial due to the collective misconduct of the prosecutors. If they had complied with their ethical and legal obligations, the jury might not have convicted Senator Stevens. I think it is important that we try to understand how and why the government botched this prosecution before considering whether we need legislative changes. I am also interested to know that what, if anything, DOJ has done in response to the problems that have been uncovered in the Stevens prosecution. DOJ undertook an internal review of the Stevens prosecutors, the results of which were leaked to the press over a year ago. Despite the Attorney General's public pronouncements to Congress that he plans on sharing the DOJ report, he has not done so. We invited DOJ to send a representative to testify at this hearing, but the department declined the invitation. I look forward to discussing this very troubling matter today with Mr. Shoki and the other panel of witnesses which we have scheduled to testify, and I now yield to the gentleman from Virginia, Mr. Scott, for his opening statement.
Thank you, Mr. Chairman. I'm pleased to join you for this hearing regarding the prosecutorial misconduct in the case involving former Senator Ted Stevens of Alaska. I commend the Attorney General for taking decisive action after the findings that you have outlined to dismiss and in dismissing the prosecution of Senator Stevens with prejudice upon learning of the misconduct. I understand that his department's decision not to comment on the matter during the Office of Professional Responsibility review, but it is clear from other cases that the problem is greater than just the Stevens case, and I'm concerned about whether or not there are sufficient safeguards in place to prevent such disturbing cases from occurring in the future. The government is given enormous powers over individuals in the criminal justice system, including the power to jeopardize and take away their freedom, even their lives in some cases. In exercising such enormous power over individuals, it is incumbent upon the criminal justice system to ensure basic fairness to them. And when the government conceals information in a prosecution that could undermine its case against the defendant, such concealment is fundamentally and constitutionally unfair, as well as unethical, and it is actually illegal under Brady v. Maryland and in other cases. Generally, a defendant will have no way to know of or learn of exculpatory evidence known to the government unless the government discloses it. Given the adversarial relationship between the government and the defendant in criminal cases and the natural desire of human beings, including prosecutors, to win a case, there are strong temptations not to reveal case weaknesses. Therefore, there must be strong disincentives as well as obligations for the government to overcome such temptations. I believe that the Attorney General and his staff have demonstrated and continue to demonstrate commendable responsibility in revealing the failures of the department to meet its obligations in the Stevens case. However, I'm not convinced that the dependence on after-the-fact actions by an individual Attorney General and disciplinary proceedings against individual attorneys for their failures to reveal exculpatory evidence, if discovered, is a strong enough standard to prevent such problems from occurring in the future. In other recent cases, including potential cases among those reported in recent newspaper articles regarding unrevealed, discredited scientific evidence relied upon for convictions of hundreds of defendants, caused me to believe that stronger requirements than those currently in place need to be considered. Also, we have several letters that I'll offer for the record, signed by dozens of criminal justice professionals and observers, including many former prosecutors, calling for stronger measures as safeguards against concealment of exculpatory information by prosecutors. I look forward to any light the testimony of our witnesses may shed on these issues. I also look forward to working with you, Mr. Chairman, and the Department of Justice to assure the effective measures are in place to prevent such cases as Senator Stevens' case from occurring in the future. Thank you, and I yield back.
Thank you, and without objection, the letters referred to by the gentleman from Virginia will be put into the record. The ranking member of the full committee, the gentleman from Michigan, Mr. Conyers.
Thank you, Chairman Sensenbrenner, and I commend you and Ranking Member Scott for your statements, which I concur with, and will merely submit my opening for the record and observe that the Brady Rule is being violated in other respects as well. In other words, there are people that don't have the rank of United States Senator who are no doubt being affected by violations of the Brady Rule. And so it's in that spirit that I commend both the chairman and subcommittee, the ranking member, for the work that they've done in this regard. And I will yield back the balance of the time and yield briefly to Bobby Scott.
Thank you. Mr. Chairman, I just wanted to mention for the record the statement from the Department of Justice, a letter from the National Association of Criminal Defense Lawyers, ACLU, and a letter from the Constitutional Project that has almost 150 signatories.
Without objection, the material will be included. Without objection, all members' opening statements will be included at this time. I would now like to introduce today's witnesses on the first panel. Henry F. Schulke III is a partner in the law firm Janus, Schulke & Wexler. Mr. Schulke was named by Judge Emmett Sullivan to serve as special counsel to investigate the prosecution of Senator Ted Stevens. Mr. Schulke previously served twice as special counsel to the U.S. Senate. He served as an assistant United States attorney for the District of Columbia, and following his graduation from law school, he served for 4 years in the Judge Advocate General's Corps. He received his undergraduate degree from St. Peter's College and his law degree from Villanova University. The chair is going to swear witnesses at this hearing, so Mr. Schulke, would you please stand and raise your right hand? You solemnly swear that the testimony that you are about to give to this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. I ask you summarize your testimony in 5 minutes or less. We have the red, yellow, and green lights before you, and when the light turns red, it indicates that the 5 minutes have expired. Mr. Schulke.
Thank you, Mr. Chairman. Mr. Scott, Mr. Conyers, good morning. I appear this morning at the committee's invitation to answer such questions as the committee might have concerning the investigation that my colleague William B. Shields and I performed having been ordered to do so by the Honorable Emmett G. Sullivan of the United States District Court for the District of Columbia. I understand that the committee has our report, and I am prepared to respond to the committee's questions. I should like to observe that we had the complete cooperation of the Department of Justice as we undertook this investigation, as well as that of its Office of Professional Responsibility. And with that, Mr. Chairman, I am prepared to answer your questions.
Thank you very much, Mr. Shoki.
Mr. Chairman, I'm not sure, is this microphone working?
Working fine.
Good.
First of all, can you describe the willful non-disclosures of Brady and Giglio material you found during the course of your investigation?
I can. I found that the prosecutors, Messrs. Bottini and Gecki in particular, failed to disclose exculpatory information provided to them by the then anticipated government witness, Mr. Rocky Williams, concerning his understanding, based on a conversation that he had with Senator Stevens and Bill Allen before the renovation project ever began, that whatever time and material that Allen's company, Vico, was to provide on the renovation would be included in the bills submitted to Senator and Mrs. Stevens by the general contractor whom they had engaged, Christensen Builders. And that, consistent with that understanding, it was his practice on a monthly basis to retrieve the Christensen Builders invoices, check them for accuracy, take them to Allen's office so that his time and other Vico employees' time could be added to the bills before they were sent to Senator and Mrs. Stevens.
Do you think that the failure to disclose this exculpatory information would have had an impact on the outcome of the trial?
I do. It was altogether consistent with Senator Stevens' defense, which the government well anticipated and forecast. When Senator Stevens and Mrs. Stevens testified during the course of the trial, that they understood and believed that they had paid all the bills, because they did indeed pay all the Christensen Builders bills to the tune of $160,000. That testimony was not only challenged in cross-examination and in closing argument by the government, it was ridiculed. Had the government's own witness, who was the foreman on the job, testified to the understanding which I just described, I believe it would have had a significant impact on the outcome. Secondly, the government, since 2004, that is 4 years before the Stevens trial commenced, was in possession of evidence that its principal witness, Mr. Allen, had suborned a false statement from a young, teenaged prostitute with whom it was alleged that he had had a sexual relationship. That information, which clearly would have been admissible to impeach Mr. Allen's credibility, namely that he had suborned a false statement, was not disclosed to the defense. It was not disclosed to the Stevens defense in 2008, nor was it disclosed in the course of 2 trials conducted in the District of Alaska 1 year before the Stevens trial. Peter Cott and Victor Coring were 2 Alaska state legislators who were indicted, tried, and convicted for bribery offenses The principal government witness in both of those cases was Mr. Allen, who had, according to the government, and ultimately according to Mr. Allen's guilty plea, paid the bribes to those two state legislators. The evidence of Mr. Allen's subornation of a false statement was not provided to either of them. Either this was a pattern that prevailed over the space of 3 trials conducted over 1 year.
What do you think motivated the prosecutors to do this?
As I testified when I was asked that question by the Senate Judiciary Committee a couple of weeks ago, I said that I believed that it was the adversary's desire to win and not to disclose to the defense information which would have hurt the government's case. That is my view today.
So it was win at all costs and not to have justice served?
I think that's a fair characterization, yes.
Okay. Thank you. My time has expired. Gentleman from Virginia, Mr. Scott.
Thank you. Mr. Shoki, when Attorney General Holder came in, what was the status of the Stevens case? I understand that he had been found guilty by the jury, but the judge had not entered the guilty verdict. Is that where we were?
When Attorney General Holder took office, the trial had been concluded, you are correct, and the jury had returned a guilty verdict, and post-trial proceedings were underway. That is, motions for a new trial.
Had the judge entered the guilty verdict?
Well, if you mean, Mr. Scott, was there a conviction entered, the answer is no, because a conviction occurs as a matter of law only when sentence is imposed. And of course, the case never got to that point.
You hadn't gotten to the sentencing phase. What did the Attorney General find out that provoked his investigation? Someone got some, the defense counsel got some tips as to what might have happened?
A couple of things, Mr. Scott. As Chairman Sensenbrenner observed, there was an FBI agent whose name was Chad Joy who filed essentially a whistleblower complaint, making a number of allegations about the conduct of the lead FBI agent on the case as well as the prosecutors. That prompted post-trial motions brought by Senator Stevens' counsel. In the process of responding to those motions, as Chairman Sensenbrenner also observed, Judge Sullivan found 2 of the government prosecutors to have been in civil contempt for failure to have produced certain records which he had ordered in connection with those proceedings. At that point, the Department of Justice appointed a new team of prosecutors to represent the United States in the course of these post-trial proceedings. Those 3 prosecutors commenced an investigation, and they focused initially on the most dramatic testimony delivered by Mr. Allen in the trial, namely that a letter that he'd received from Senator Stevens asking him to make sure and send him a bill was just Senator Stevens covering his ass. Based upon a conversation Mr. Allen claimed to recall with a mutual friend of his and Senator Stevens in Alaska. That testimony was, as one might imagine, dramatic and damning to Senator Stevens' defense that he acted at all times with a pure intent. As these new prosecutors focused on this, they began to review some internal emails between and among the prosecution team and found a series of emails that were obviously contemporaneous to an interview of Mr. Allen 5 months before the trial. I say contemporaneous, meaning it was obvious that they were emailing back and forth while the interview was in progress. They were curious about this exchange and, in short, ultimately found the handwritten notes of that interview, which had been recorded by 2 of the prosecutors. Ultimately, the handwritten notes of 2 more prosecutors and the lead FBI agent were also discovered. All of those notes reflected that Mr. Allen was asked during that interview whether he remembered the note he got from Ted Stevens and whether he remembered speaking to Mr. Persons, the one to whom he at trial attributed the cover your ass comment. And all of those notes reflected that he either said no, he did not recall speaking to Persons, or he didn't recall speaking to Persons.
And my time is almost up, but as a result of those findings, the new team of lawyers made a motion to dismiss the case with prejudice.
That is correct. The new team of lawyers, as I understand it, recommended that that be the course taken by the department, and the Attorney General authorized a motion to dismiss with prejudice, which, of course, Judge Sullivan granted.
Thank you. Gentleman from South Carolina, Mr. Gowdy.
Thank you, Mr. Chairman. Mr. Schulke, if I heard you correctly, Senator Stevens paid $160,000 for the improvements made, the addition. Did I hear you correctly?
Yes, sir, you did.
What was the fair market value of the additions or changes made to the lodge?
The fair market value of the house after the renovations was $152,000.
Were the bills paid contemporaneous with their being submitted? In other words, was he paying the bills in a timely fashion, or was it a circumstance where got a lot of bills towards the end?
No, the Christensen Builders bills were paid in the regular course by Mrs. Catherine Stevens upon receipt. The Stevenses, in order to finance this project, had taken a second mortgage, liquidating $100,000 in cash for the project, had liquidated a $10,000 trust, and spent from their savings as well. And that is how they timely paid the $160,000 worth of Christensen invoices.
Well, here's what I'm struggling with. I actually like prosecutors. I actually like federal prosecutors.
I used to be one.
So when I say what I'm getting ready to say, it's not by virtue of a criticism towards them, but they're not known for taking really close cases that could go either way unless they have to, particularly against a high-profile defendant. State prosecutors have to roll the dice more than federal prosecutors do. So if you have a high-profile defendant with a really good defense team, and your allegation is that he unjustly enriched himself via gifts, and the evidence is he actually paid more than the value of the home, what am I missing? Why was the case ever brought in the first place? It doesn't seem to be a very good case from a factual standpoint.
Well, the government had evidence that Bill Allen's company, Vico, had provided labor and materials to the project, and it was the government's theory of the case that Senator Stevens well knew that that had occurred, acknowledged at least late in the process that he knew that, which is why he sent the note to Mr. Allen asking him, please send me a bill for whatever work you did. And the government contended that Vico's contribution to this project, as was alleged in the indictment, was $250,000. Now, at trial, when the government introduced the records of the Vico Corporation, which purported to establish this $250,000 figure, it was demonstrated that the records were simply inaccurate. They, for example, logged 8 hours a day, 5 or 6 days a week for Rocky Williams. He didn't work 8 hours a day, 5 or 6 days a week on the project. They logged 8 hours a day, 5 days a week for another Vico employee, Dave Anderson, who wasn't even in Alaska for several months during that period of time. And Judge Sullivan, upon the motion of Senator Stevens' defense counsel, concluded that those records were false and excluded the majority of those records.
All right, my light is on, so let me ask you this, which is kind of related, I guess, somewhat. Well, before I ask you that, the federal prosecutors weren't interviewing these witnesses without the Bureau being present, were they? I mean, they're not crazy enough to do witness prep without a law enforcement agent present, were they?
As a general practice, they did have FBI agents and on occasion agents of the Internal Revenue Service accompany them for purposes of interviews.
This may or may not be true because it's been reported, which carries no presumption of credibility, that there is this movement to change Brady Giglio, the discovery rules, because of this case. There's a senator from Alaska that's introduced legislation. It strikes me that if the rules as they existed had been followed, you and I wouldn't be having this conversation.
Well, I think that's quite right, Mr. Gowdy. It has been the law since the Supreme Court decided the Brady case and the Giglio case that the government is obligated to disclose material exculpatory information. I don't believe that this materiality issue, which I personally think is a problem that needs to be addressed, was a determining factor in the problems that occurred in the Stevens case. But I do think it is a problem that needs to be addressed. I have seen Senator Murkowski's proposed bill. I don't know that I'm in a position to subscribe to it in its entirety, but to the extent that it would eliminate the materiality requirement with respect to the disclosure of exculpatory material, I think it is welcome and necessary.
Gentleman's time has expired. Gentleman from Michigan, Conyers.
Thank you, Mr. Chairman. I first want to thank you for coming before us today. And I just want to take a moment to look at the larger question of Brady rule violations and how we ought to look at them. I understand the subcommittee may be considering looking at other kinds of cases like this, and it might add some dimension to the problem. So I'd just like you to tell us about your impressions of whether the Brady rule needs strengthening or whether we need to get a way for the prosecutors to actually look at it more and use it more appropriately.
Yes, sir. I shall try, Mr. Conyers. First of all, we should all understand that the Supreme Court has, for years, announced the rule that in order for a conviction to be reversed for the government's failure to provide exculpatory information, that failure must have had an outcome determinative effect. That is to say, are we left in a situation where we can have no confidence in the verdict because of the failure to disclose Brady information? That's the materiality concept, which in my judgment is perfectly sensible and appropriate from that post hoc appellate perspective. Now, we're in the pretrial situation. The prosecutor has an obligation to disclose Brady material. The prosecutor says, and they have argued in court repeatedly, they did in the Stevens case, well, we're only obligated to disclose material exculpatory information. Now, mind you, the prosecutor is one of the adversaries in this process. In my judgment, it is not appropriate for one of the adversaries to be the self-appointed gatekeeper for what may be exculpatory information that the defense, consistent with its strategy, may be in a position to pursue and to use in the course of the trial. And this adversarial process, which is a general proposition I applaud, leaves one in a situation where there is a considerable risk for mischief. If I'm the prosecutor and I say, here's this little tidbit which is in my files, which reflects adversely on the credibility of my star witness, it's really not material. I don't think I have to turn that over. Human nature is such that good people, motivated by this adversarial desire to prevail, make those kinds of judgments. They should not. And it's for that reason that I believe, as I have testified, that the materiality requirement with respect to pre-trial disclosure of Brady material should be eliminated.
Is it fair in closing to ask you whether this kind of problem occurs perhaps more than we on the Judiciary Committee could be aware of?
Well, that's a very good question, Mr. Conyers. One never knows what one doesn't know. Based on my experience, both as a prosecutor and a defense attorney for now over 40 years, I do not personally believe that there is a pervasive non-disclosure problem in the thousands and thousands of cases that are brought by the Department of Justice. There have been a number of celebrated ones. There have been a half a dozen or so that have attracted considerable attention in the last 2 years. So it happens. And of course, one never knows if a case goes to trial and there had been no disclosure of Brady material and the defendant, for whatever reason, was not equipped to ferret it out. If there was not a Judge Sullivan presiding over the matter, one never knows. But it is my personal view, based on my experience, that it is not a widespread, pervasive problem in the Department of Justice. And I know that the department, since the Stevens case, has taken significant steps, both in terms of policy prescription and training to address this problem.
Gentlemen's
Thank you for
time.
your views.
Gentlemen's time has
Thank you for your
expired.
views.
Wilkinson.
We are expecting about 25 minutes of votes pretty soon, and then there'll be a second series of votes later on. I'd kind of like to speed this hearing up and not to impose undue time delays upon our witnesses, to do what we can in shuttling us in and out. So the chair recognizes the gentleman from Texas, Mr. Gomert.
Thank you, Mr. Chairman. We know that we had an FBI agent, Joy, that filed a whistleblower complaint against DOJ. As of November 2008, how long had FBI agent Joy been working for the FBI?
Mr. Goldman, I don't remember precisely how long. He was quite young and inexperienced.
And still had the courage to come forward with the information. That's very impressive. Because one of my concerns over the FBI 5-year up or out policy that this director implemented, it drove thousands of years of FBI experience out of the FBI and left people with much less experience in charge. And my experience from having been a prosecutor in my early days out of law school was, you know, you're hard charging and you need somebody, maybe not as smart as you, but somebody with experience to say, this is not a good idea, that you should not put a case in jeopardy. We're about justice, and that means your title forces you to disclose Brady material, whether there's a Brady case or not. You're about justice. You're not about winning at all costs. And some people have a hard time understanding that and understanding their role. And I got to tell you, just my perceptions, I was not a big fan of Ted Stevens. When I heard and saw and read the information coming from the Justice Department, sounded like, gee, this guy really had, you know, over $100,000, $200,000 of benefits come his way, and that really is abusive. This is a bad situation. And then when you find out the real facts, he paid more than the value of the structure, and then you find out that, gee, they knew not only his theory, they had his notes where he was saying, give me the bill, let me pay the bill. And as you've said, his wife was paying them as they came in, and they end up paying more than the value of the structure itself. It's just hard to imagine prosecutors, justice officials, FBI officials, because I've got a lot of friends in the FBI, a lot of people I have so much respect for, and I do disagree with you that it's an adversary should not be a gatekeeper. If they understand their goal, their end is justice, not to win at all costs, as you said, I don't think this is a widespread problem. But I'm wondering, and having been a judge and a chief justice, I've sat on disbarment cases back in Texas in state court. I don't know why anybody that literally took the life that Ted Stevens built and destroyed it, took his life, why they should ever be allowed to practice law again if they do not understand the trust and betrayed it as they did here. And I understand your recommendations with regard to contempt of court. You looked at the burden of proof. Have there been any actions taken to pull the ticket, to disbar these people that would ruin a man's life at the end of his life in such a way by withholding evidence? It sure seems it would have made a heck of a difference. If I'm a judge here in the case without a jury and I find out the structure's worth less than he paid, that he has notes out there that he gave timely manner and said, give me the bills, and the evidence was his wife paid the bills as they came in, and then it turns out there's evidence of the key witness involved with a prostitute. Can we say prostitute? Okay. Involved with a prostitute. I cannot imagine why they should be allowed to practice law again for ruining this man's life. Have you looked at possible disbarment?
If the gentleman will yield, you can use that word because the Washington Post has used it quite a bit in the last week.
Ah, okay. Well, have you looked at disbarment recommendation?
I have not, Mr. Goldman. It's beyond my charter, and I don't have a view on that subject.
You don't have a view at all?
I don't.
Not even personally?
I don't care to take a view on that.
Okay. You could have one, but you don't care to take a view.
The gentleman's time has expired. The bell has rung. We have 3 votes. I'm going to recess the committee, and I will admonish both Mr. Johnson and Mr. Pierre-Louisi to be back promptly after the last vote of this series. Otherwise, we will move on. Without objection, the committee is recessed until after the last vote of the series. Subcommittee will be in order. The chair recognizes the gentleman from Georgia, Mr. Johnson.
Thank you, Mr. Chairman, for holding this very important committee meeting on this issue. Ted Stevens was a gentleman who I met for the first time Christmas of 2007, and we were both standing in line together at the White House Christmas celebration, waiting to shake hands with the president. And while he was there, I think it was his wife and a couple of his daughters were with him, and they were very jovial and just real, just regular, normal people. I know they have hearts and feelings and that kind of thing, and they were happy. And Senator Stevens was spry, kind of cantankerous, and he was irascible, but I liked him. He seemed to be a good, proud man, used to being in authority and in control. I can only imagine how he must have felt when the jury announced the verdict of guilty in this case. And in this case, it was in 2004 that the government knew that the principal witness, Bill Allen, had suborned perjury by getting a prostitute to testify or make a false statement under oath. Is that correct, Mr. Skokie?
Yes, sir, that is correct.
And was Mr. Allen prosecuted for that?
He was not.
But that was a note that was in, or that was evidence that was in the file of the prosecution in the Stevens case.
Yes, the young woman had been interviewed by an FBI agent. And
Okay, I'll stop you there. Just wanting to clear up the facts. And that same information was available in a federal prosecution of the two cases prior to Senator Stevens' trial. And those two cases involving state legislators were federal trials as well. Is that correct?
That's correct.
And so we have 3 instances of failure to disclose subordination of perjury. That would have been material information, would it not?
Yes, sir.
And pursuant to Giglio, that information should have been disclosed, as well as Brady.
It's Giglio material, I would say.
Yeah. So, and then during the trial in 2008, the prosecution failed to disclose, or during the Ted Stevens case, the prosecution failed to disclose written information in the files in the way of case notes that the prosecutors had written down what a witness was telling them, that witness being Rocky Williams. And then also that information would have been material also in your opinion. Is that correct?
I believe that was material Brady information, yes, sir.
And then you have already testified about the fact that the prosecutors derided Senator Stevens' principal defense, which was that I have this note here, and it shows that I requested so-and-so to send me a bill. And the prosecutors allowed the witness, Bill Allen, to testify falsely that he was just trying to cover up his ass.
Well, the note from Senator Stevens in 2002 to Mr. Allen said, Bill, when I think of all the ways you helped me, I lose count, but you have to send me a bill.
Okay,
And,
all right.
and I'm going to have Bob Persons talk to you, so don't get PO'd at him.
Okay.
6 years later, Allen testified at the trial.
Okay, we're getting into the weeds now. I just wanted that particular statement. My time's getting ready to run out, and I hate to interrupt you. But why was there no prosecution recommendation to charge any of the prosecutors with the same charge that probably should have been leveled against Bill Allen back in 2004? It's 18 U.S.C. 1622, subornation of perjury. And has there been a recommendation to the state bar of the state where these gentlemen, the prosecutors, practiced?
Not that I'm aware of.
And they've not been prosecuted, no recommendation, no sanction has been applied to them?
To the Stevens prosecutors?
Yes.
Not that I'm aware of.
And you do say, though, that Senator McCoskey's legislation should go a little bit further and make sure that the gatekeeper is not the sole keeper of that file insofar as Brady and Giglio materials are concerned. Do you think that it would be a good idea for the judge to have to look at that case, look at the case file, make a determination independently that there is no, or all information that should have been disclosed has been disclosed, and then seal that, file a copy of that file, what he's reviewed in the clerk's office for purposes of later appeals? Do you think that's a reasonable way of going about getting this responsibility out of
It is a reasonable way of going about it, assuming that the prosecutor first says, I am in doubt about whether I should disclose this. I will submit it to the judge in camera and let the judge decide. But the prosecutor first has to get to that point in his own analysis.
The gentleman's time has expired. The gentleman from Puerto Rico, Mr. Pierre Luisi.
Good morning, Mr. Skolky.
Good morning, sir.
As I understand the Supreme Court case law, the Supreme Court has set a constitutional minimum in this area. So states, and I would assume also this Congress can set a higher standard and change the rule so that it is more favorable to the defense and to the process as a whole. You mentioned before that in your view, the materiality requirement shouldn't be there. I heard that. Apart from that, do you have any other suggestions to us in terms of how to go about changing the rule? Are we talking about amending Rule 16? And if so, in what fashion would you recommend that we do so?
Well, as you may know, sir, the Rules Committee of the Federal Judiciary has been contemplating such a change since 2006, I believe, and has rejected suggestions that Rule 16 be amended to accomplish this purpose. As I recall, when most recently the Rules Committee took it up, they had available to them a poll that was taken of sitting federal judges across the country, and slightly in excess of 50% of the federal judges recommended an amendment to the rule. The Justice Department opposed such an amendment, and the views of the Justice Department, as I understand it, carried the day. So I persist in the view that such a change is necessary, and while it could be accomplished by an amendment to Rule 16, that has not occurred, and I think if the Rules Committee is not going to do it, the Congress should.
And in your view, is the prosecutor's intent to use or not to use the evidence a relevant factor here or not?
I'm not sure I understand the question. The
Well-
prosecutor's intent to,
Yeah, because some of the case law seems to suggest and rules also that one of the relevant factors in determining whether you turn over this type of evidence to the defense is whether the prosecutor intends to use it at trial. And in my view, that shouldn't be a factor, and I want to hear from you about it.
I quite agree, that should not be, and I don't know that it typically is a factor.
Okay. And we've been talking about Congress. Now, would you turn your attention to DOJ? The U.S. Attorney Manual, as you know, is binding on the prosecutors and internally can be used for disciplinary purposes, but it has no bearing, it has no remedy for the defense. So that's a flaw. I've seen that they have made some revisions to it. I've seen that training has been enhanced in this area. Is there anything else that the Department of Justice should be doing so that this type of conduct doesn't happen again?
Well, as you've pointed out, the department, through its U.S. Attorney's Manual, has a provision which has recently been revised, together with guidance from the then Deputy Attorney General Ogden, right after the Stevens trial, which, as a matter of policy, tells the federal prosecutors that they are to disclose Brady and Giglio material. They are to take a liberal view of it, and they are not to, in most cases, they are not to impose this materiality standard. As you've also observed, the U.S. Attorney's Manual has an explicit disclaimer that these policy pronouncements do not have the force of law, and they vest in no one any rights. I believe if the Justice Department, as expressed in the U.S. Attorney's Manual, is of the view that the materiality requirement ought to be eliminated, then I see no principled reason why they would oppose legislation which does, of course, have the force of law to accomplish the same thing.
Thank you.
Gentleman's time has expired. The gentlewoman from Florida, Ms. Adams.
Thank you, Mr. Chairman. Knowing that, how was the Stevens trial team structured?
How was it structured? Very shortly before the indictment was returned in July of 2008, Brenda Morris, who was a deputy chief of the Public Integrity Section, who up until that point had very limited involvement in the Stevens investigation, was tapped by the Office of the Assistant Attorney General for the Criminal Division to be the lead trial prosecutor. The team in the courtroom, in addition to Ms. Morris, was Mr. Nicholas Marsh and Mr. Joseph Bottini. Mr. Marsh was a public integrity lawyer, and Mr. Bottini was an assistant U.S. attorney in the District of Alaska. They had significant experience in this public corruption investigation in Alaska because Mr. Gakey, the other Alaska assistant U.S. attorney, and Mr. Marsh tried the first of the two state legislators whose cases I have described, and Mr. Bottini and a young public integrity lawyer named Edward Sullivan tried the other one. So that was the composition of the trial team.
Do you believe that the 6 prosecutors who were the subject of your inquiry were candid, forthright, truthful with you during the course of your investigation?
I believe that they were.
Can you explain your references in the report to the simultaneous and collective memory failure of, I guess it's Messrs, Bottini, Marsh, Gakey, and Sullivan to recall the details of their interview with Bill Allen on April 15th, 2008?
Can I explain the memory failure?
Your references to that? Because you just said they
All
were
of
being
them.
forthright, so.
All of them participated in the interview of Mr. Allen on April the 15th of 2008. All of them took notes in which they recorded what he said. 5 months later, Mr. Allen has a dramatically different, indeed a polar opposite account from the one he gave them in April, and all of them, to a person, maintained that they had no memory of him having said what he said on April the 15th. As I say in the report, I was unable to determine by compelling evidence that any one of them, in fact, remembered what had transpired in that April interview and falsely represented that they had not.
At this time, I yield to Mr. Gowdy.
Was this what we sometimes refer to as an open file case, or did they try to follow the statute?
Well, in the Stevens case,
Right.
it was not a so-called open file discovery practice.
If DOJ adopted an open file status for all of its cases, how many of the concerns raised by our colleagues on the other side would go away?
Some, but not all.
Can you give me an example of something that is potentially impeachment material but not material? Doesn't meet the materiality element, but is potentially impeachment, giglio material.
I suppose a witness could testify at a trial that the crime he or she observed occurred on a Tuesday. And that witness could have testified, or in the course of an interview earlier stated, that it occurred on a Thursday. The accounts of the events themselves might, in both the interview and the trial testimony, been otherwise altogether consistent. And one can make an argument that the witness's memory at one point, months ago, that it was a Tuesday versus memory that it was a Thursday at the trial is not material.
Well, my time is out, but I appreciate your testimony, and I would hope you would come back at some point. You're a former prosecutor. There are other former prosecutors up here. Reciprocal discovery is something I would like to get your perspective on as well, because can't call the name of any criminal defense attorneys, at least in my experience, that have been disciplined in any way for not meeting the reciprocal discovery requirements, and that may be a source of frustration for prosecutors.
The gentlewoman's time has expired. Mr. Schulke, thank you very much, not only for coming today and answering the questions that we all have relative to this prosecution and your report, but also the extensive time you spent putting together an extremely thorough report on a very messy and sad experience in the history of the Justice Department. So I think the entire country should thank you for your efforts on that, and hopefully your report and what has transpired in the Stevens case will prevent this from happening again. So thank you.
Thank you, Mr. Chairman. I appreciate your hospitality.
Yeah, thank you. Okay, we will now go to the second panel of witnesses. Kenneth Weinstein is a partner in the law firm of Cadwalader, Wickersham, and Tapp, where his practice focuses on corporate internal investigations. He is also an adjunct professor at Georgetown Law School. Mr. Weinstein served as an assistant U.S. attorney both in the Southern District of New York and the District of Columbia. Later, he served as the U.S. Attorney in the District of Columbia and then was the first Assistant Attorney General for National Security. He served as FBI Director Robert Mueller's Chief of Staff and then as President Bush's Homeland Security Advisor. He received his undergraduate degree from the University of Virginia and his law degree from the University of California at Berkeley. Alan Barron is the senior counsel at the law firm of Seyfarth Shaw, where his practice focuses on white-collar criminal defense. He has served as special impeachment counsel to the U.S. House of Representatives 3 times. And most recently, he was special counsel in the impeachment of Judges Samuel Kent and G. Thomas Porteous. He also was Minority Chief Counsel to the Senate Governmental Affairs Committee and served as an Assistant U.S. Attorney in Maryland. He received his undergraduate degree from Princeton and his law degree from Harvard. As I said earlier, I will swear the witnesses in. Could the two witnesses please stand, raise your right hand? Do you and each of you solemnly swear that the testimony you are about to give to this committee be the truth, the whole truth, and nothing but the truth, so help you God? Let the record show that both witnesses answered in the affirmative. The written statements will be entered in the record in their entirety, and you all have been up here before, so you know about green lights, yellow lights, and red lights. Mr. Weinstein.
Ranking Member Scott, members of the subcommittee. I'm here with two of my colleagues, Jeffrey Nessler and Sarah's Deb, and together we're proud to represent Assistant United States Attorney Joe Bettini in this matter. We're here today for one reason, to demonstrate that the special prosecutor got it simply wrong when he found that Joe intentionally violated the rules in the Stevens case. First, let me take a minute on who Joe is. Joe's a 27-year veteran of the Alaska U.S. Attorney's Office. He's universally respected by the Alaska bench and bar and has never had a single allegation of misconduct against him. He's tried and prosecuted hundreds of cases, and the only recognition he wants in life is to be counted among those prosecutors who go to work each day seeking to do justice for the American people. In short, and in my eyes, Joe is a model public servant. Joe's also something else. He's human. He makes mistakes. He acknowledges he made mistakes, serious mistakes, in the Senator Stevens case. And he acknowledges and he greatly regrets the impact those mistakes had on the integrity of that trial and on the public's perception of the Justice Department. But Joe does not acknowledge, I do not acknowledge, and most importantly, the facts do not acknowledge that Joe committed those errors purposely or with any bad faith. The Special Prosecutor's report, as you know, concluded definitively that he did. While the report goes on for some 500-odd pages, it really distills down to just two findings about Joe. One, a finding that Joe committed errors, and two, a finding that those errors were intentional. What's completely missing, however, is any connective tissue between those two findings, any actual support for the conclusion that Joe's errors were intentional as opposed to inadvertent. In fact, there's really no analysis of Joe's intent at all. We've carefully gone through the 514 pages and have found a grand total of one paragraph that purports to analyze the intent behind Joe's conduct. One single paragraph for the most critical question in the whole investigation. Professional prosecutors understand that every error is not a crime, and that they have a duty to carefully distinguish between mistake and misconduct before concluding that somebody is guilty of an intentional crime. The Special Prosecutor's report failed to uphold that duty in just about every respect. First, the report fails to take into account the chaotic conditions under which the prosecutors were working before and during trial, and the chairman mentioned these earlier today. Circumstances that made it likely that balls would be dropped and made it therefore more likely that mistake rather than misconduct was behind any errors. Circumstances such as the complete failure by the Public Integrity Section management to do its job, the severely shortened time period for trial preparation, and the combative defense tactics that kept the prosecutors off balance during trial. All highly relevant circumstances and none given any real consideration by the report. Second failing, the report fails to consider critically important mitigating circumstances, such as the fact that Joe is universally admired by his defense counsel adversaries as, quote, a man of high moral character, and as, quote, the kind of person for whom the expression straight arrow was invented. And also, the fact that on 7 different occasions, Joe actually pushed his Public Integrity Section supervisors to disclose the very information the Special Prosecutor's report accuses him of trying to suppress, requests that were firmly denied each time. Third failing, the report mischaracterizes important facts in a way that puts a nefarious slant on Joe's conduct by saying, for example, that Joe made a prejudicial argument in his closing jury address, an argument that is not found in the jury trial transcript. The report altogether ignores other facts, facts that cut against its findings. For instance, the report finds Joe guilty of suppressing Rocky Williams' assumption about the senator paying for the work on his house, but never addresses the fact that Joe's outline for his direct examination of Rocky Williams had an entry showing that Joe intended to elicit that very assumption on the record in open court, a circumstance that completely undermines a finding of intentional misconduct and a circumstance that should have been front and center in any credible consideration of that issue. And as a final failing, the report reflects a process that showed very little regard for fairness, and most troublingly, in the way the investigation concluded, with no criminal charges, but with a public branding of our client as a proven criminal. Under our system, professional prosecutors have one way and only one way to accuse a person of a crime, and that's with the filing of formal charges that the person can then contest in open court to defend his liberty and his reputation. That rule was not followed in this case. The special prosecutor decided not to file charges against Joe, but then turned around and publicly declared to the world that Joe was guilty of the worst thing one can say about a federal prosecutor, that he's dishonest and a cheat. This left Joe with the shame of a criminal accusation, but without any opportunity to show the American people that that accusation was wrong. Today, thanks to this hearing, we finally have that opportunity, and we're very grateful to the committee for giving it to us. I look forward to this hearing, and I look forward to answering any questions you may have for me.
Thank you very much, Mr. Barron.
Thank you, Mr. Chairman. As you noted in introducing me, you mentioned that I had been an assistant United States attorney for Maryland. I think I would only add to that during that time, I headed the investigation which led to the indictment of a former United States Senator, Daniel Brewster of Maryland. And I'm aware, therefore, although it was a long time ago, of the pressure that put on a prosecutor when he's involved in a case of such magnitude and importance. I would note that I have no connection, whatever, to the Stevens case. I have no relationship with any of the individuals involved in that matter, other than having had minimal contact with Mr. Welch relative to the Porteous impeachment. I join with the chairman in commending Mr. Schulke for his comprehensive report. In my view, it's clearly the product of an enormous amount of effort conducted in a highly professional manner. So for purposes of my testimony, I accept the accuracy of his findings of fact, specifically that by any standard, and I think I want to keep those words in mind, by any standard, the information provided to the prosecutors by Rocky Williams and Bambi Tyree was Brady material. And Mr. Schulke concluded that both Mr. Bottini and Mr. Gecky consciously withheld and concealed this critical information from the defense, and indeed that there were affirmative misrepresentations regarding the Tyree information to the effect that such material did not even exist. And then Mr. Schulke also found that Mr. Bottini failed to take steps to correct false testimony by Mr. Allen on the witness stand, at which testimony Mr. Bottini knew to be false in violation of the Supreme Court case NAPU versus Illinois. Mr. Schulke was appointed to investigate and prosecute criminal contempt proceedings as may be appropriate against the prosecutors in this case. Despite having the findings that we've all referred to this morning, Mr. Schulke ultimately concluded that no prosecution for criminal contempt would lie. According to Mr. Schulke, at a hearing on September 10, 2008, the judge in the Stevens case failed to issue, I'm quoting now from the report, a clear, specific, and unequivocal order such that it would support a finding by a district court beyond a reasonable doubt that 18 U.S.C. section 4013, that is the criminal contempt statute, had been violated. In my view, and I certainly defer to Mr. Schulke's report, wherever it purports to find facts and reach conclusions based on the enormous investigative effort which clearly underlies it. But the entire transcript of the proceedings on September 10, 2008 is available for review. Anyone here can read. That is the entire universe contained in that transcript. And one can therefore reach one's own conclusion as to what transpired at that critical event. And here, I must regrettably and respectfully disagree with Mr. Schulke's characterization of what occurred. On September 10, 2008, the court issued a clear, unequivocal order to the government to produce material pursuant to Brady and its progeny. Everyone agreed that they understood their obligation. None of the prosecutors asked for clarification of what was being ordered. We must recall Mr. Schulke's earlier conclusion that by any standard, even the narrowest view of what Brady requires, the Williams and Tyree materials had to be disclosed as Brady material. In my view, failure, if you accept Mr. Schulke's factual premise, the failure to disclose what were clear Brady materials was in direct violation of the court's order. Now, the fact that there was no written order entered on September 10th is irrelevant. It's well established that no written order is required. And it is noteworthy that Mr. Weinstein, who represents Mr. Bottini in a letter to the Attorney General dated March 15th, 2012, acknowledges A, that no written order is required for a contempt proceeding, and that the judge's verbal order at the September 10th, 2008 hearing was clear and unequivocal. To me, the judge's order was clear, as was its violation. The question is, how did this happen? In a sense, it's a bigger issue. The obvious answer is that overzealous prosecutors got caught up in a win-at-all-costs mentality and ignored their obligation to prosecute fairly and within the limits imposed by the Constitution. But I think there's a deeper question here. There seems to have been a total breakdown of supervision. Who was in charge? Who would accept responsibility to rein in prosecutors when they begin to violate their constitutional obligations? What I find, and we can talk about this perhaps in response to questions, because I see my time is elapsing, what I see here is a total breakdown in supervision. You might ask, why do experienced prosecutors need supervision? Because it puts someone in a position where they must account for what happens. And when you don't have that structure, you get the problem of people going off and essentially doing their own thing, very much to the detriment of the administration of justice. Thank you.
Thank you, Mr. Barrett. Mr. Weinstein, I think that Mr. Bottini was very clearly the most experienced of the prosecutors that were prosecuting Senator Stevens. And I just look at the long litany of errors that occurred and ignoring the judge's admonition. For example, during one hearing, the judge admonished the prosecutors that the government has an obligation to turn over the Brady and Giglio information, and if they don't want to do that, they ought to resign. And then there were some letters that Mr. Bottini authored relative to the Brady and Giglio issues that were sent to counsel for Senator Stevens. And one of those letters, Mr. Bottini failed to include significant Brady information presented or provided to him by Rocky Williams, which a few days earlier corroborated Senator Stevens' primary defense. In your written testimony, you said Mr. Bottini only skimmed the second of the two Brady letters, which also, according to Mr. Shoki, contained significant misstatements and concealed the importance of important Brady and Giglio information. At trial, Mr. Bottini did not correct Bill Allen's false testimony on cross-examination. There on September 10th, the judge issued a clear order to the prosecutors to comply with Brady and Giglio, or it would support a criminal contempt prosecution. Mr. Williams was sent to Alaska, and Mr. Bottini apparently had some role in making that decision. Mr. Allen suborned perjury. That information was not disclosed. And Mr. Bottini did not produce to counsel for Senator Stevens' April 15th, 2008 interview notes of Bill Allen pursuant to Brady or Giglio. Now, it's going on again and again, and we know of at least two admonitions from the bench to either produce the information, resign, or face criminal prosecution. Mr. Allen's false testimony was not corrected on cross-examination. Now, this is an experienced prosecutor, and it was up to the Department of Justice to determine when to file the indictment. Senator Stevens was up for re-election 4 months after the indictment was filed. And as one who has run for office numerous times, it's pretty hard to get re-elected when you're indicted and don't have an opportunity to have a jury decide your guilt or innocence. And that's the timing that the Justice Department undertook in determining when to file the indictment, I think practically guaranteed that Senator Stevens' attorneys would have asked for a very speedy trial. And finally, there was the complaint that the defense counsel was very aggressive in the presentation of their case. Now, it's been a long time before I've tried cases, or since I've tried cases in court, and I always thought that the counsel, pursuant to rules, was on an ethical obligation to present a vigorous case for their trial. You say that Mr. Bottini was caught up in the milieu of the trial and the lack of supervision from on high, but he was so experienced, couldn't he overcome that? Or couldn't he throw the red flag down on the field and tell his superiors in the Justice Department that they ought to have a hand on the tiller? Basically, what I hear from you, Mr. Weinstein, is that, well, he did the best he could under the circumstances, and it was the folks up above him that kind of dropped the ball. And I'll give you a chance to answer my 4.5 minutes of a litany of, things that are in the report. And forget about the red light, because I'm not going to ask a follow-up question.
Thank you, Mr. Chairman. Yeah, you gave me a lot to chew on here. Let me start off first. Joe is not pointing the fingers at the people above him, and he's not saying that he didn't do anything wrong. He will say he wishes he did throw a flag. He just bore down and worked on his little area and didn't say, you know what, we really need to do this. We need to stop the presses here, go back to the beginning, and try to fix this. And he wishes he did. So he's not saying that this is all somebody else's fault. He's accepting responsibility for the mistakes and the miscalculations he made. Another thing I'd like to mention is, you mentioned zealous advocacy by defense counsel. I'm not complaining about their work. They're very successful defense counsel, and they do a great job for their clients. My only point is that's a circumstance that kept the prosecutors on their heels, confused, running, here and there, and they never really got their sea legs in trial. And that's one of the reasons why mistakes were more likely, because the critical thing that we focused on is there intentional conduct here, or is it mistaken conduct? And the circumstances that we've laid out here are laid out with the intention of showing you that this really was a series of mistakes. Now, you've laid out a number of the things that the report indicates that my client is guilty of. Now, of course, you're characterizing the facts as characterized in the report. You're accepting the conclusions that these things were done intentionally, and I understand that because your basis of knowledge is the report. What I'm doing is, on behalf of Joe, and frankly on behalf of the other subjects, pushing back on those assertions by the special prosecutor, because I think the special prosecutor, like you, did a tremendous service to the country here, and it was a tremendous challenge what he had to deal with. But I believe he got some of the facts wrong, and he got the inferences wrong. So if you look at a few of the things you raised, it's not so clear-cut. For instance, the question about whether Bill Allen provided perjured testimony or wrong testimony that Joe should have corrected. If you actually go back and look at the record, you'll see why Joe realized he was totally confused, and the jury Joe had already advised the jury that Mr. Allen had some cognitive impairments, that he had some serious problems, and those problems had actually played out while he was on the stand. The jury understood that he would get confused, and he got confused. And the last, I think his final question was, hell, I don't know what day it was that I talked about this. Joe's recognition, he explained this to Mr. Schulke, was, I realized he was confused. If I tried to clean it up, it would just get worse. And the critical thing is that Joe did not use that information, did not try to take advantage of it in his closing argument by suggesting that Allen had not just recently told them this information. He didn't exploit it at all, even though defense counsel raised that issue. My point is, he had a reason for what he did, which was not nefarious, was in fact understandable. Rocky Williams, the only other example I'd like to cite, he talked about how he learned that Rocky Williams had this assumption that Senator Stevens is going to pay for that work. He did. Rocky Williams told Joe this, and Joe thought about it. He's explained this to Mr. Schulke. He thought about, boy, this is an assumption by a person who's working on a work site that the guy who owns that work site, the house there, is going to pay for that work. Is that something that we need to turn over to the defense? He asked a critical question. Did you, Mr. Williams, Rocky Williams, tell the senator or the senator's wife that the charges for the work were all going to be put in the Christensen Builder bills that you're paying? No, I didn't, but I assumed that. Well, frankly, Joe's thinking was everybody on that work site assumes that the owner of the house is paying for the construction on that house. I think we'd all assume that. That's not something that can be elicited on the stand. That's a speculation. It's not something that's disclosable. Now, you can take issue with that decision. My point is, he had a reasonable basis for the decision he made that is far from a criminal intent to hide facts that should have gotten to the defense, even though one can question whether, in retrospect, he should have made the other decision.
Thank you. The gentleman from Virginia, Mr. Scott.
Thank you, Mr. Chairman. Mr. Chairman, I'm not as concerned about the individual prosecutors involved. Their fate will be determined in another forum. But it does show, I think it's clear from, particularly from what we've heard from the chairman and from the gentleman from South Carolina, that things didn't go right in this trial. It should have been treated differently. And if this kind of stuff happens in a high-profile case like this, you can only imagine what happens in the run-of-the-mill cases. Most cases, this kind of information would never come to light. And so we have a question of whether or not we need to change our procedures, particularly in light of the laboratory scandal that's just come to light. And so in terms of what the standard ought to be going forward, does anybody think admissibility ought to be part of the standard? If it's evidence, the Brady information has to be admissible. I know in civil standards, if it would lead to admissible evidence, it would help impeach witnesses, if it would help the investigation, even if it's hearsay, or if it helps settlement, you can get discovery in civil cases. And it has nothing to do with admissibility. Should admissibility be part of the standard going forward?
Let me respond. Usually when you're talking about Brady material, it's material that the prosecution does not want admitted. I mean, because it's going to tend to be exculpatory. It may be material that the defense wants to admit, and certainly if it is relevant and material, it certainly should be admitted, if that's your question.
Well, should that be part of the standard? It wouldn't have to be admissible evidence. I mean, you could be hearsay at other things that are clearly inadmissible that would be helpful to the prosecution. So admissibility is not going to be part of the
Right.
any
It should
kind
not,
of standard.
admissibility of the evidence in and of itself should not be the standard. It's whether it might lead to
Okay.
evidence that could be used in that way.
So we're back to material. Is there any suggestion that the standard on review, on appellate review, ought to be different? The standard on appellate review suggests that the availability of the material of the Brady material could have changed the result. Could have, not necessarily, but could have. Is there any suggestion that that standard on appellate review be changed?
I think there's talk about that. I don't know that I see problems with that. If you were to change to take materiality out of the appellate standard, then every little deviation, let's say to talk about in the Giglio context, impeachment, and use the example that we cited, that Mr. Schuelke cited before, about a Tuesday versus a Thursday, you'd be litigating every little discrepancy, so there would be no finality to cases, and you'd end up with cases being reversed for what really is not outcome determinative.
So if all these proposals will not change the standard on appellate review, are we just talking about good practice and not really changing the law?
I think that the materiality standard, I think Mr. Schuelke made the point earlier, it's very difficult for someone who's a prosecutor to put himself in the shoes of defense counsel in a hotly contested case and figure out what's material, what's not material, what's relevant, what's not relevant. Indeed, the prosecutor may not really know just what this defense strategy is going to be. How can he make the judgment in a vacuum? So I think that to the extent that one continues to impose a materiality standard, it makes it harder and harder for the prosecutor to make a judgment that's sound. And so therefore I think that's the push of removing that standard, because it's unrealistic to expect the prosecutor to make that judgment, and indeed very difficult for an appellate court to make that judgment.
Well, particularly because neither may know what the defense knew, and this could be the key little connection that could help them make their case. It would be material to the defense, but the prosecution had no way of knowing that it was that important information.
Exactly.
Now, on appellate review, if it turns out that way and you hadn't released it, you would have a Brady problem.
Yes.
And so we're talking about good practice. Don't get into Brady problems that you can avoid. Just let it all, just release it all. But you're not talking about changing the standard on review. If it in fact was not material, then there should be, are you suggesting that there's no sanction?
I think that to the extent that on appellate review, the court, it's going to be a pretty extreme case that where an appellate court will feel it's in a position to, let's say, reverse a conviction for failure to disclose, I think will be materials evidence. I agree with Mr. Weinstein that to the extent you don't want the appellate courts getting bogged down in every relatively minor instance that something was not turned over. If it would not have had some material effect, it seems to me that that's asking too much. I think you bog down, you clog the system with a lot of cases on appeal where it shouldn't be happening.
Thank you, Mr. Chairman.
I thank the gentleman from Virginia. Mr. Weinstein, I don't really care about how zealous or not zealous defense counsel was. I'd rather have good facts and good lawyers. And it just strikes me that the facts weren't good, which means maybe I'm missing something. If you paid $170,000 for something whose fair market value is $160,000, even Mr. Scott can't win that case if he's a prosecutor. I don't think. So am I missing fact? I mean, look, I want to be sympathetic to prosecutors. I was one for a long time, but what am I missing?
Good question, sir. And just keeping in mind that I represent Joe Bettini, and I'll say that Joe was not involved in the decision to charge the case. So the decision was made to charge the case. He was actually surprised that an indictment actually was filed.
It's not hard to get an indictment.
Sorry?
It's not tough to get an indictment.
No. I'm not making the point that there's anything that passed some threshold. I'm just saying the fact that it was actually issued caught him by surprise. He was off working on a capital case out in Alaska when it was issued. But you know, having been in Maine justice for quite some time, I've often seen where you have a case that looks a certain way at the indictment stage, and then especially when good defense counsel, and now we had good defense counsel here, get involved, it starts to morph and starts to look different. And I'm only speculating because I wasn't inside this process, but sometimes that happens where the facts just get worse. I think everybody would question, why the case was charged. You got to remember, it's tough if you have what looks like a makeable case against a sitting United States senator. Charging has its consequences, but not charging also has its consequences. So it's a tough. I just think the people in that position were in a tough position.
All right, you were at DOJ for a time period. This practice of interviewing witnesses without the case agent present, which at best may potentially make you a witness, at worst leads to what we're talking about here. Wouldn't that have corrected it if you'd had a bureau agent or an IRS agent or the case agent present for the interview?
Yes, I mean, in most cases they did, as far as I know, and I think Mr. Sulke, who's sort of the expert on the facts, indicated that he thought that there was an agent, either an FBI or IRS agent, not always the case agent. One of the problems was in a couple of the critical interviews, a 302, an FBI report was not generated. And especially in the interview of Bill Allen on April 15, 2008, where he made the critical comment or statement, which he then changed as he got closer to trial, there was no 302 written of that. And that's one of the problems in the case, because the prosecutors didn't have a written record, which they could have looked at and said, oh, wait a minute, what Bill Allen's saying now in September is different from what he said in April. So that was really the main problem. I don't believe were instances where they went forward without agents. I mean, they were smart. They get it that, yeah, if you go in there without an agent, you're going to make yourself a witness in case something arises at trial that harks back to that interview.
Well, as you probably have noticed, Congress is much better at doing autopsies than it is at doing well checkups. We like to wait till something horrible happens, and then we rush in with a long list of cures, most of which are cures for symptoms that don't exist. But it does sully the name of 99% of the prosecutors who actually do value the administration of justice more than they do results. And you don't ever make the news when you don't drop the baby. It's only when you do that you have your counsel at a House Judiciary Committee hearing. So do the rules need to change? Does the law need to change? Or is this just a case where the rules are sufficient, they just weren't followed?
I'm not going to pretend to be the world's expert on this issue because my focus in this has been different. It's been Joe. But I think, as someone has said earlier, the rules here were sufficient. And I think, especially in the aftermath of this, I give a lot of credit to the department for what they did, where they've tightened up training, expanded training, and their whole focus is, okay, we're going to give guidance to the prosecutors that they turn over all exculpatory, all favorable information to the defense without regard to the materiality requirement. But we want the law to be materiality requirement, so that if we don't turn over the Tuesday versus Thursday thing because we just overlooked it, that we're not going to then put a conviction in jeopardy or really undermine the process of criminal justice.
So an open file policy, but not an open file law.
Well, I don't know that I'd say open file, just more prosecutor's job is to turn it over, whether it's through open file or just telling them, providing the relevant documents to the defense if they find something favorable, and don't just hold on to it because it's not favorable information that's material. And I think having that as the policy guidance and the law being, okay, but we only actually take action against the prosecutors and against their case if it was material information that wasn't turned over, I think that's a good approach and well-trained and well carried out and well-supervised. 99.999% of the criminal trials should go smoothly.
My time is up, and I think the chairman's back.
Thank you, Mr. Chairman. There's two issues that I'm concerned with. One is the prosecution being the gatekeeper or the keeper of the file and having the unbridled discretion with which to decide whether or not to disclose information that might be exculpatory to guilt or of impeachment value to the defense. And so with that unbridled discretion, it means that most failures to disclose evidence will never be decided or will never be discovered, because at no point during the initial prosecution, the trial, the appeal, at no point does the defense have the right to peruse the entire prosecution file. And so, and I can tell you that this is not the first time this has happened. It happens many times. It even happened in a death penalty case that I handled out of Georgia, that we got the case reversed because the prosecutor used perjured testimony, knowingly used perjured testimony. This is in a death penalty case. And so this desire to win at all costs, I'm afraid, is a little more prevalent than we may admit. And then my second problem is that whenever it is discovered, then nothing happens to the prosecutor. People think that lawyers are, make up a kind of a good old boy club type situation, and they are supposed to discipline themselves. They don't want another outside force outside of the bar to discipline lawyers. And that's why under most state bar rules, lawyers have an obligation to, when a substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer is in question, then they have a obligation by of their state bar association to disclose that information. And but we don't get we have a reluctance to disclose misconduct. It's like tattling on our club member, and that, if it continues, will result in a public demand that the power to discipline lawyer misconduct be put in the hands of non-lawyers, and I don't think we want that. So we need to be cognizant of our obligation to disclose any case where there may be a question about whether or not something was untruthful or not. Now, as far as a remedy for this situation, upon motion of a defense counsel or the state for an in-camera review of the entire state's file and a continuing obligation thereafter to disclose all the way through appeal such information, to require that by statute, to require that the court do that by statute. Is that a workable solution to this first problem that I cited about prosecutor being the unbridled gatekeeper? Mr. Barron?
Yes. I think it's a nice idea, but I think from a practical matter, there would be something of an uproar by the judges that they don't have the time to be burdened with that. And also, they know about a case, they may have had a couple of hearings in it, but they don't know the case in depth. And so to put that burden on them and expect them to be the gatekeeper, even though we like the fact that they are neutral, rather than a prosecutor who is in an adversarial process, it's a huge burden to impose on the courts. And I think implicit in your question is, how do we legislate integrity? Because, and can we? Because ultimately what we see from what Mr. Schulke found in his report, even if you had had open file discovery, complete access, things never got into the file that should have been there. Or 302s, the FBI interview form, were edited in such fashion that the exculpatory information was left out and the inculpatory stuff was left in. So ultimately, even the most prophylactic approach is going to turn on the integrity of the people who are serving as prosecutors. I think some of these steps might be a step in the right direction, but we shouldn't kid ourselves. If what happened here, if Mr. Schulke is right about what happened here, this was really pretty terrible. Let's not put too, I don't want to put too fine a point on this. It's pretty terrible. And if prosecutors engage in that kind of conduct, no amount of reviewing the file is going to really reveal that, because they were hiding things, according to Mr. Schulke, and that's pretty awful.
The gentleman's time has expired. Gentlewoman from Florida, Ms. Adams.
Thank you, Mr. Chairman. That kind of is very bothersome to me as a law enforcement officer. So you mentioned on your opening statement the breakdown in supervision. Would you like to elaborate on it? Would you care to elaborate on it a little bit further? I think from what you're saying here, there was a definite breakdown.
Yes, of course. I have, over the course of my career, run a number of investigations, some very big ones where I had a dozen lawyers and a dozen forensic auditors conducting an investigation, and much smaller ones where there were 3 or 4 of us. What seems to have happened here was very interesting. When Mr. Schulke was asked to describe what was the administrative structure, he started with the trial itself. But who was running the show for the 2 years that the investigation was going on? When I read the report, I couldn't figure out who was in charge, which is kind of shocking. And I think can lead to all kinds of problems. The thing is that even when Brenda Morris was appointed, apparently she was appointed the lead prosecutor a few days before the indictment came down. She apparently, prior to that, according to her, a submission she made, had basically declined several times taking the role of lead prosecutor. I don't know why she ultimately accepted, whether she was pressured into it or decided it was a good idea. But in any event, and to push somebody into that spot was not a good decision. But then it gets worse. According to her own testimony, she decided that she would make herself small in her role as now the lead prosecutor. That could only make a bad situation worse. It's basically saying, even though I'm accepting the role of lead prosecutor and all the responsibility that comes with that, I'm not going to exercise it. I'm not going to do that. In the absence of that, all kinds of very bad things happen. There has to be a hierarchy when you are running an investigation or when you're running a case. Because with hierarchy comes structure, and with structure comes accountability. You can't have people milling around on their own making these decisions. You need somebody who steps up and says, I am going to lead this, and if things go bad, I'm going to be responsible for it, and I'm going to give everybody direction. That didn't happen here. It doesn't excuse the misconduct, but it helps explain it.
Thank you. Mr. Weinstein, your specific criticism about Mr. Schulke's, the way he conducted his investigation, what are they? And his conclusions? What are they? What are your specific criticisms about the way it was handled?
Well, I guess the general criticism is that he looked at what were clearly mistakes, very serious mistakes made on behalf of the whole trial team, and my client participated in those mistakes as well and was responsible for some. He looked at those mistakes, he gauged them as being very serious and having a serious impact on the integrity of the trial, and I don't take any issue with any of that. But then he concluded that they were intentional. And that's the very critical thing that I'm focusing on here. Because that, in my book, and I think former prosecutors here would all agree, if you find a prosecutor who intentionally broke the rules, punish them to the hilt. That's it. Throw the book at them. Because one bad apple is going to have serious ramifications, not only for that person, that person's trial, but for the whole Justice Department. But that's very different, though, from making mistakes. And that's why I want to focus, and I think he didn't focus sufficiently on the circumstances that were very difficult for these prosecutors that caused them to make mistakes they shouldn't have made, but nonetheless they were inadvertent as opposed to intentional. So that's really
Didn't the court give you an opportunity to comment on Mr. Schulke's report and have those appended to the report?
The report was...
Did they give you the opportunity, the court?
The court gave us the opportunity, after announcing the conclusions, to provide a criticism that could be appended to the report, but not to provide any input that might have any impact on the outcome of the report.
Did you choose to do so?
I submitted a 50 or so page memo that we provided before that wasn't even mentioned in the report with a cover memo, and then Joe said his main concern was talking to his colleagues and the Attorney General and the Justice Department, so we went along.
So you submitted that to the courts to have it appended?
And that was appended, yes, ma'am. Yes.
Okay.
And then we also provided a letter to the Attorney General.
Which, if any, of the Brady-Giglio violations described in Mr. Schulke's report do you take issue with?
Well, I don't take issue with, well, there are a couple where he determines it's a Brady violation. I think there's an argument that it's not a Brady violation. My criticism is not so much that these were violations. So if you're looking at it from the perspective of Senator Stevens, he was denied a fair process, no question about it. My criticism, as I explained earlier, is Mr. Schulke's determination that those violations on the part of Joe were intentional. And my point is, no, they were not intentional, they were mistakes.
Gentlewoman's time has expired. Gentlewoman from Texas, Ms. Jackson Lee.
I thank the chairman and ranking member for this hearing and thank the witnesses for their presence and express my deep concern over this question. And I really refer to the numbers of individuals who have been released on the under the new premise of DNA evidence as led by the Innocence Project. And the reason why I mention it is because a lot of that has occurred in the state of Texas. And I know that we are looking at a number of differing issues, but I think the underlying premise, what I want to speak to, is when people are convicted wrongly and they are incarcerated inappropriately because of either lack of expanded evidence, unwillingness to investigate evidence, and then, of course, not presenting evidence or not sharing evidence. And so, Mr. Weinstein, within the limits of what you can say, what is the status of your case, of your client? Where is it? Is the case completed, or you're still in the process of defense of this individual?
I'm representing him for purposes of the investigation that was conducted by Mr. Schulke. I also happen to be representing him in regard to the internal disciplinary process in the Justice Department, and that is not completed.
And is he, or she, is presently still a functioning prosecutor?
Yes, Mr. Bettini, 27-year AUSA, Assistant U.S. Attorney, and is in court, going in and out of court every day, doing everything from meth cases to he's doing a case involving a militia, members of a militia who've threatened to kill a federal judge. So he's still going in there and doing.
So is it in the public domain, and as to the reason, is it in the public domain based upon Mr. Schulke's report, why he did not present that evidence? Is that in the public domain?
Yes, our submissions to Mr. Schulke, in which I explained the reasons why these discovery violations happened on the part of Joe, and explained how they were mistakes, that is in the public domain. That was released with the Schulke report. So yes, people see that, and hopefully people are hearing today that there is another side to the story, not just a finding of intentional misconduct.
And I don't want to litigate your case, but I guess since it is in a public domain and I missed Mr. Schulke's report, is the explanation that the paperwork was voluminous, and that it didn't come to his attention? What is the parameters of the explanation of the mistake?
Well, there are several different things that Mr. Schulke is accused him of doing wrong, and he did make mistakes. He didn't turn over several things that should have been disclosed.
That he was aware of?
He was aware of, but he didn't. One thing he forgot. Another thing, he made an assessment that it was something that didn't need to be turned over. Another thing, he tried to get it disclosed, but his supervisors wouldn't let him. 7 times he said to his supervisors in the public integrity section, you got to get this out. We got to disclose it, and they shut him down. And in fact, the section chief supervisor sent an email saying, you work for public integrity. These are your marching orders. Stand down. So that's why that information didn't get out.
Without litigating his case here, if I just take the parameters or the framework that you've just given, I would assume then that we look at this question of either prosecutorial abuse or misconduct. We need to look up the chain and try to understand what supervisors are told and what they're not. Let me quickly ask, this proposed legislation that has been suggested that might clarify Brady material, would that be helpful in knowing and having more detailed procedures for presenting or finding evidence? Both of you, any of you?
I would say that eliminating the materiality requirement for a prosecutor to take into consideration in making a Brady or Giglio judgment, I think that is a step in the right direction.
So that means they would just present what they had, and you don't have the discretion to say, no, this is not really relevant, I won't keep this, I'll keep this. Is that what you're saying?
Well, as I understand the legislation, the prosecutor's not to say, gee, this might help them, but I don't think it's really material.
Right.
That discretion is taken away. It's supposed to be turned over, even though the issue of materiality, that's not going to be addressed. You have to turn it over if it might be helpful to the other side.
All right, I think this is crucial in terms of what happened to Senator Stevens, and in his death, I apologize to what happened, and I hope we can correct this situation.
Yes.
Thank you. I yield back.
The time of the gentlewoman has expired. I'd like to thank all of our witnesses for their testimony today. Without objection, all members will have 5 legislative days to submit to the chair additional written questions for the witnesses, which we will forward and ask them to respond as promptly as they can so their answers may be part of the record. Without objection, all members will have 5 legislative days to submit additional materials for inclusion in the record. Now, in closing, let me say that this is probably one of the blackest incidents in the history of the Justice Department, because by their misconduct, they ruined the reputation of a senior United States senator and probably caused his defeat in the election, both by their timing of the indictment, how the trial was conducted, the lack of supervision by the Justice Department, and the like. I think the culpability here goes beyond the trial team that actually prosecuted Senator Stevens. There's plenty of evidence that there was a lacking of supervision, that the Public Integrity Section wanted to get Senator Stevens one way or the other. And even though some members of the public integrity section have been exonerated in the internal review of the Justice Department, there has to be a view beyond the Justice Department into exactly what happened. All of us in law school are reminded that in addition to being advocates for our clients, we are also officers of the court. And as officers of the court, we have taken an oath to attempt to have justice administered fairly and impartially, which means that it's based upon all of the evidence in the applicable law. As one of my colleagues on the panel has indicated earlier, I think that this terrible miscarriage of justice warrants the investigation of the D.C. Bar into whether any of those who are involved in this should be disciplined with penalties up to disbarment. I don't trust the Justice Department to conduct an impartial investigation. We have heard time and time again that the marching orders were to win at all costs and to forget about the administration of justice. That is something that is profoundly troubling to me, and I think to anybody who looks at this objectively. I'm not saying that any one person should possibly be disbarred, but I am saying that the D.C. Bar ought to look at this away from the old boys and girls network in the Justice Department and impose what discipline that is warranted on whomever was responsible for what happened in this trial. This is not the first time the public integrity section has gone overboard. We had the case a couple of decades ago of former Congressman Joe McDade of Pennsylvania, who basically spent his life savings and then some to get an acquittal verdict from a jury for essentially doing casework for constituents. So I think that what has to happen here is the message has to get out that any prosecutor who does something like this, their career and their bar license may be on the line for doing something that is outrageous and egregious. You know, I'm not a bar commissioner. I think that they ought to look at the evidence on this, but they ought to look at it. So with that, without objection, the subcommittee is adjourned.